Okay, we're going to go ahead and start. First, I wanted to say thank you for tuning in this morning. We really appreciate it, and we're excited to be here with you today for your celebration of Sandra Day O'Connor. So that's really exciting. I know that she's one of my heroes, and I know that Mary Beth feels the same. So I'm sure that will come out along the way today. We want to pass on your welcome from Tammy Waller, who is having technical difficulties. She's actually with us, logged in, but may or may not be able to participate today. So we do also thank the Arizona Department of Education for allowing us to be part of the celebration with you all today. So our subject today is student speech from Armbands to Snapchat. And we have with us our special guest, Mary Beth Tinker, who I will introduce in just a moment. And I'll introduce the people from Street Law as well who are on. We're going to ask that you please do not record today. We are recording, so we will provide you with a YouTube link if you want to use this recording later on in your classrooms. This is our agenda today. We're going to do a very quick welcome, overview, and introductions because we want to get to the good stuff. And then we're going to spend a significant amount of time talking about Mary Beth's case that went up to the Supreme Court, Tinker v. Des Moines Independent School District. And then we're going to move into, we'll talk about some other cases that happened in between that case and this very recent case. And then we're going to bring it to last term and the very hottest case of last term, Mahanoy Area School District VBL, the case about the cheerleader Snapchat. We're going to look at how the two cases connect. So how the Supreme Court looked at Mary Beth's case and they applied that to this recent case, even though certainly when her case was decided in 1969, there was no such thing as Snapchat. And we're going to do Q&A with Mary Beth at the end, but I'm going to put a little caveat on that and say that we're really going to do Q&A throughout because we know that some of you may not be able to stay with us until the very end of the presentation. So, so even though it says it at the end of the agenda, consider it sort of throughout the presentation as well. So there are a couple ways to participate in this webinar. So for students, if your teacher allows you to use your cell phone in class for educational purposes, and only if, and we'll pause for a moment for teachers to help make that decision with you all. You are free to text us at that number, 240-863-2406. And with your questions about things that come up as we're talking, if you have questions, please feel free to text us your questions. And the Q&A function is available if you're logged in, but I believe that's mostly teachers. So teachers can use the Q&A function to leave questions. So if your students are asking questions in the classroom, if you maybe have a way for them to slip you questions, like they can write it on a piece of paper and hand it to you, we will be able to take the questions from the Q&A as well, even though we know students don't really have access to the Q&A. So I'm going to pause for a moment for teachers to talk to their classes about how they'd like to submit questions. And teachers, maybe you can write that number somewhere that's available for students to see throughout the presentation. So I'm just going to pause for a moment for you all to be able to have that conversation in your classrooms. Okay, teachers, I also just dropped that number in the chat. So in case I'm moving away from the slide before you were able to write it somewhere, that number is in the chat. I'll introduce the facilitators today. So I'm Kathy Ruffing, and I am the Senior Director for Teacher Professional Development Programs and Curriculum at Street Law. I recently retired after teaching for 27 years in public school in Virginia. And Mary Beth used to come in and speak to my classes on a regular basis, which was really special for them. I'm going to move over to Bianca, who will introduce herself.
Hi, everyone. I'm Bianca Rizzio. I recently joined the team at Street Law as the program coordinator, and you'll be hearing from me today as I pop in and out with some questions.
Thanks, Bianca. And our third member is Ben Marks. He's kind of silenced and has his camera turned off, but he's our communications coordinator, and he's really here to troubleshoot technology. So, so if you have technology issues, you can send him a message. He would be in the chat as Street Law webinars. So you can just chat him or Bianca. I don't want to spend a lot of time on street law and who we are, but I'm sure your teachers always teach you that you should consider the source when you are being presented with information. So we do want to tell you a little bit about who we are. We are a nonprofit organization, and we exist to try to empower people with knowledge about the law and civics so they can make positive changes. And that's what we do. We're right outside of DC. So Bianca's in Baltimore and I'm in Virginia. So we're sort of spread throughout the DC area today. We've been around for 50 years. This is our 50th anniversary. Okay, so now we're getting to the part that you really want to hear about. And that is Mary Beth Tinker. So Mary Beth is one of the litigants in this case, in the case we're going to talk about first, Tinker v. Des Moines. So she's going to tell you all about that today, but she was probably younger than a lot of you, or the same age, when she was the subject of a major Supreme Court case. And since then, she has been really an advocate for student speech. She sometimes travels to locations where students are exerting their rights, and she lends her voice to their causes. She is a lifelong educator. So I mentioned the fact that she spoke to my classes. She's been in a lot of classrooms. She traveled the country in what they called the Tinker Tour on the anniversary of the decision. And since the pandemic has really zoomed into many, many classrooms, so feels really passionate about speaking directly to students. She's also a retired pediatric nurse, so it's dedicated her whole career to young people and their health. And she's also lives up to her ideals and stays really active in DC local politics. And makes her voice heard. So I'm going to throw it over to Mary Beth to say a little bit about herself before we move into her really landmark case.
Thank you so much, Kathy. It's so good to be with all of you today, students, teachers, and Tammy Waller. I am so glad to be part of this program. I was invited to Arizona a few times by Tammy Waller and others, and I remember speaking once with some teachers at the program, and they told me a story about Sandra Day O'Connor, and we're honoring her devotion to civics today for youth, that she has been active. And through her lifetime, she believes that young people should know about the Constitution, know their rights, and then act on them and put them into action. So the teachers were telling me a story about how they saw Sandra Day O'Connor one time at a program, and they went up to her and they talked to her about civics, and they asked her, how can we get students more excited about, you know, their rights and getting involved in taking action? And she said, well, what about that armband case? Maybe you could talk to them about that armband case and they would be interested in that. So we all laughed about that. And we did talk to students about that armband case. And I'm glad to be talking with all of you again about it today. And I'm excited that you are learning your rights. And thank you to all the teachers out there for teaching students. And thank you to all of you students also for hanging in there in these hard, difficult times. And I'm so glad that we're all together today talking about democracy and young people being part of that democracy.
Great, thanks, Mary Beth. Okay, we're going to jump into the case since you've heard a little bit about it. It's about armbands. And you might have already studied this case in some of your classes or already talked about it this year. But if not, we're gonna start from the beginning. And of course, the beginning is the First Amendment to the Constitution. So anytime you look at a Supreme Court case or anytime you think about what your rights are, it's best to go to the source being the Constitution. So this is what First Amendment says about speech. Congress shall make no law abridging the freedom of speech. So that's very simple. It's only a couple words, but because it is very simple, it's been interpreted over and over and over again by the Supreme Court. So, where does that freedom of speech stop? So that we're going to really delve into that today. And student speech is even a more unique type of speech because there are restrictions on student speech that aren't there for everybody. So one of the very first Supreme Court issues about speech in schools had to do with the flag salute. And there was actually a case before this case that you're seeing here called Minersville v. Gobitis. And it happened shortly before this case. And it was a case about students who belong to the Church of Jesus Christ of the Latter-day Saints. And they wanted to, they were Jehovah's Witnesses. And they had a problem saying the Pledge of Allegiance in class or saluting the flag because their religion said that they shouldn't put anything above God and that it wasn't right to pledge allegiance to anything but God. And in that case, the Supreme Court found that the school could make them salute the flag. But it was such a negative outcome of that case. So the students were persecuted in their community. The Supreme Court realized very quickly that it was not the solution that they had hoped for. And so they very quickly reversed their decision in that case, which rarely happens. Sometimes the Supreme Court reverses their decision over many, many years, but to reverse their decision that quickly doesn't happen often. So in just a couple of years, they took this case, West Virginia State Board of Education v. Barnett. And I love this picture because it shows you how students saluted the flag in 1943. Looks very different than the way we salute the flag in 2021. So this was a straight arm salute, and you're probably already imagining that the reason this salute changed was because when Nazism became a movement, and this kind of looks like the Nazi salute, although it's a little different. In the United States, we changed the way we salute the flag. But in this case, the Supreme Court reversed their decision and said that schools couldn't force students to say the Pledge of Allegiance to salute the flag. And this was a victory for students because now we focus more on what can students say, but in this case, it was more what do they have to say? What can the school compel them to say? And this was both a free speech case and a freedom of religion case because it really boiled down to the fact that it violated certain students' freedom of religion. Mary Beth, do you have anything to add? Because I know you really care about that case too.
No, it's just that one time I was speaking in a school with fifth graders about these rights, and one of the students asked, "Did you know that go bite us, children?" So I had to laugh because this all happened before I was even born.
That's great. Okay, so another really important part of the Constitution that makes this the First Amendment reach to your schools is the 14th Amendment. So the 14th Amendment says that no state can make or enforce any laws which abridges the privileges and immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. So this is an important amendment because before the 14th Amendment, the answer to the question, does your school have to listen to the First Amendment when it thinks about your rights, would have been no. But after the 14th Amendment, which was passed shortly after the Civil War, it says the states have to give you your First Amendment rights. Okay, so we're going to jump into Mary Beth Tinker's case now to find out the details of this case so that you can decide whether or not the First Amendment protected Mary Beth and her brother and her friends from the school action. I don't want to say too much. I'm not trying not to be a total spoiler. Okay, so Mary Beth, can you tell us a little bit about why you wore armbands to school?
Yes, I will. Well, we grew up in what a student recently called mighty times, and it's kind of like now when there's so much going on and so many issues. And so we heard a lot about things going on. And one of the things that we heard about was kids who were speaking up and using their rights in Birmingham, Alabama. And here are some of the children, the teenagers of the Birmingham Children's Crusade. This would be a great project for a school sometime, kids. It's amazing. Almost 2,000 kids that year in Birmingham marched and protested against segregation. Because, I mean, they couldn't even go into a store to try on clothes. They couldn't be served at restaurants. It was 1963 in May. And so thanks to the free press, and by the way, the First Amendment is free speech, free press, freedom to assemble, freedom to petition, and the freedom to have your own religion and for the state not to tell you what religion you should have. So these kids were using one of their, well, a couple of their rights, the freedom to assemble and the freedom to free speech. And Martin Luther King was there in Birmingham, but he had been put in jail already for speaking up against segregation. And so he was writing a very famous thing called the Letter from Birmingham Jail. And sometime you should read that. And basically the message of that letter was that now is always the time to speak up about what's right. So the kids said, we are going to do that. And I saw these young people on the news and we thought they were so amazing and brave and strong. I was living in Iowa with my family. My dad was a Methodist minister and my parents also were examples of people speaking up and putting their values into action. They believed that if you preach about love and understanding and those things that we learned in church, that you should put those into action in your daily life. And so that's the way that we were raised, with these examples. Well, to punish, well, that was in May of 1963. And then in August of 1963 was the March on Washington, where thousands and thousands of people went to Washington, D.C. to speak up for racial equality and racial justice in August. Well, then a few weeks later, right around this time of year, September 15th, 1963, the white supremacists, they, believe that white people are supreme and that white people should be in charge. And they were part of, different groups, but one of them, the Ku Klux Klan. And so these people decided to punish the Birmingham children. They were getting madder and madder about all of this. And so they developed a plan and they put a bomb in the headquarters of the Birmingham Children's Crusade, which was the 16th Street Baptist Church. And on Sunday morning, September 15th, 1963, I had just turned 11 years old when someone came by our picnic and told us that 4 little girls, their bodies had been found in the church right as they were on their way from Sunday school to the main congregation. Cynthia, Addie Mae, Carol, and Denise. They were about the same ages as me and my sisters. They were 11 to 14 years old. And so this is really a story about feelings and grief and how to express those feelings, and that young people need to be able to express these feelings. And one of the feelings is sadness. And we sure felt sad when we heard about what had happened to those brave children. And so a call went out all over the country to have services to mourn for the girls. And that's us in Des Moines. And that's the first time we wore black armbands, because there was an idea that James Baldwin, who's a writer, maybe some of you have read his work, and Bayard Rustin, another great civil rights hero, they had an idea we should wear black armbands all over the country and have memorial services for these 4 little girls. And we should not just sit by quietly for this injustice. And so that's what happened. And that's us in Des Moines. I'm in the middle, and my sister Bonnie and Hope are over to the right. And on the left are our friends Phyllis and Linda. And we wore black armbands that year for the first time. And that was my first experience with black armbands. Are a symbol of mourning, of being sad, mourning for the dead. When someone dies, you would wear a black armband on your arm to say that you're sad. Maybe you would be at work or at school or whatever you're doing, but people would know when they saw you that you're also sad about someone who died, and that you're mourning for someone maybe in your family or maybe in war, whatever, someone who had died. So it's a symbol of mourning. And that's a kind of speech, symbolic speech. Well, the next year was also amazing in those mighty times, because that year in Ohio, young people gathered, about 700 young people. And this is them in Ohio, Oxford, Ohio, training to go to Mississippi that year to help register African-American voters. Why did they have to do that? Because there was a reign of terror by the Ku Klux Klan and others. If you dared to go to register to vote and you were Black or maybe Hispanic, you could be killed. And there were already around 4,000 lynchings that had happened of African Americans. And many of those were because they had dared to register to vote. And so these young people have courage. You have great qualities, courage, creativity. You like to follow what are our ideals of democracy, equality, justice. So these young people said, we can do better than that. We need to make sure everyone can register to vote. And so they trained in Ohio, and this is them. They were scared, but they had great courage, as young people do. And so they were ready for what might happen when they got to Mississippi. And sure enough, they were in for some violence when they got to Mississippi. Their group was called the Student Nonviolent Coordinating Committee. Well, that summer when they got to Mississippi, 3 of them immediately disappeared. And sure enough, they had been murdered by the Ku Klux Klan. Their names were Andrew Goodman, Mickey Schwerner, and James Chaney. Schwerner, Goodman, and Chaney. The same day that their bodies were discovered, August 7th, 1964, in the Gulf of Tonkin off of Vietnam, a US Navy ship claimed that it was attacked. The same exact day that the bodies of the 3 civil rights workers were found in Mississippi. All of this was going on at the same time. Well, when the Navy ship claimed that it was attacked, the Congress, and by the way, it wasn't really attacked, and that's a whole story that you should learn also. And maybe some of you have family, relatives that were in Vietnam, and that would be another good thing to write about and to learn about for school. But the Congress then voted almost unanimously for the Gulf of Tonkin Resolution to start sending thousands more troops to Vietnam. We were already involved in the war in Vietnam, but most Americans really didn't know that much about it, didn't know what's going on. Most Americans couldn't even really find Vietnam on a map. They didn't know about the whole history of Vietnam or what was going on there. But after this, then thousands more troops and soldiers started being sent to Vietnam that year. So that night, by the next year, 1965, when I was 13 years old, at Christmas time, and that's us girls at Christmas time, I'm in the middle, my little sister Hope and my big sister Bonnie are there. Well, my dad would, of course, preach, and he would read to us from the Bible about the promise of hope and love that Christmas is about. And, you know, you would get those Christmas cards that had glitter on them that said peace on earth and everything. But on the news, we didn't see peace on earth. Now we saw war, war, war. And we were getting sadder and sadder. Well, thanks to the free press, people like the man who took this photo, Larry Burroughs, who was later killed in Vietnam. But thanks to people like this journalist and others, we saw what was going on in Vietnam on the news, and we were getting sadder and sadder about it, us kids. And also, it's really a family story, because by this time, my father, who was a minister, he had started working for the Quakers. And the Quakers are a group that believe in peace, and that's one of their main ideas. So we were more involved with the Quakers by this time as well. We were feeling really sad about it, and we didn't know what to do about it. And we heard about an idea that some people were going to wear black armbands again, but this time we would be wearing them to mourn the dead in Vietnam, not for the dead little girls who'd been killed in Birmingham, but this time it would be about the people in Vietnam, the soldiers, and also the Vietnamese. And that's one thing that made it so controversial. We were mourning for all the people who were being killed in the war on both sides. And that is me, and my mother is there sitting beside me, and my dad is behind me at the school board meeting. And Chris Singer over there on the left, she also wore an armband, and she was also suspended, but she didn't get involved in the court case. But when we went to school and got suspended, we went to the school board. Well, we actually went there before, and we tried to change their mind, but they would not change their mind about the rule against armbands, which they heard that we were going to be wearing black armbands. And so they called a hasty meeting of the principals and made a rule saying any child in the Des Moines, Iowa schools who wore a black armband would be asked to take it off. And if they did not, they would be suspended.
Meredith, so Bianca has a question from a student.
Yeah, Bianca.
Yes, we did have a student asking how you were someone who was chosen to be suspended if other folks or the whole school was wearing the armband as well. So hoping you can speak to that.
Yeah, no, thanks. I wasn't chosen to wear the armband, but I was the only one in my school. It was Warren Harding Junior High School. I was in 8th grade, and it was 1965. There were less than 10 kids who wore the armbands in the entire school district of 18,000 kids. Well, about 50 had planned to wear the black armbands, but then when the principals came out with their rule against wearing them, it dropped down to about 10 kids. So there weren't very many at all. And I didn't know if I should do it, but I was really sad. And I kept thinking of those brave Birmingham kids and the young people in Mississippi and how they had risked their lives. And some of them had even died to speak up about our democratic ideals, our ideals of democracy, equality, justice, and being able to speak up and express your beliefs, our First Amendment. So that's why I finally decided to do it. And my dad didn't want, my brother John was suspended, Chris Eckhart was suspended, Ross Peterson, Bruce Clark, not Ross Peterson, but Bruce Clark. There were 5 kids suspended. And my dad, he didn't think we should do it, but then we reminded our dad, my brother John and I said, but Dad, you taught us that we should speak up for our conscience. And then you told us if we don't do that, then we could have, people in charge. He had been through World War II and he didn't go to war, but he knew people who had been killed in World War II. And he said, if we don't speak up, then we could have the Nazis in charge, and we have to use our conscience and speak up. And that's what he believed. It came from his faith belief. And so we were able to convince our dad that we should speak up about the war and for peace at Christmas time.
So Mary Beth, what happened at this school board meeting, and what was their ultimate decision?
Yeah, there were quite a few people that spoke. I was so shy. I was the shyest kid you could imagine. And I didn't speak up, but Chris Eckhart gave a little speech. He was one of the students that was suspended and said that we should have our rights and we should be able to express ourselves. And some of the parents spoke up. Some students spoke up and said, no, students should not be allowed to express these things in school. And so in the end, there was a vote, and it was actually pretty close. I think it was 4-3 at the school board. 3 of the school board members did think we should be able to, wear the armbands, but in the end, they voted no, that they would continue to have the rule against armbands. It was very contentious. It was a packed meeting. There were press there. The whole thing was really intense and very emotional. Way more than I realized that I was going to be getting into.
Can we back up just a minute and go back to the day that you wore the armband and how your teacher actually confronted you and how you were suspended? Because later on, when we think about how much of a disruption you caused, we need to know those details. So can you tell us a little bit about walking through that day in school?
Yeah, it's really funny, but I had, I think, sewing class. We used to take sewing then. It was 1965. I went to several classes before lunch and nothing happened. I was so nervous, and I had on my black armband. And then after lunch, some of the boys at lunch were kind of teasing me. They sat at the boys' table and we sat at the girls' table for lunch. And the boys were like, I want an armband for Christmas. And so I just ignored them, which we always did. And then I got to my next class, which was one of my favorite classes, algebra. And Mr. Moberly, who I really liked, he was standing at the door with a pink pass to go to the office. And so I knew I was going to be in trouble. Well, the day before, he had spent most of the class talking about how students were going to be in trouble if they wore black armbands to school. And actually that came out in court later, because it wasn't really, we didn't disrupt school, but if anyone did, I guess it would be Mr. Moberly by spending the class time period talking about that. But I went down to the office and I was really nervous and scared. And Mrs. Tarman, the girls' advisor, she said, now take off that armband. And actually it was Mr. Willitson, the vice principal, first. And then later she came in too. But Mr. Willitson said to take off the armband, Mary Beth, there's a rule against armbands. So, in a great stand of courage, I looked around the office. I was so scared. I was shaking, and I took off the armband and I gave it to them. And then I went back to class, and I was really surprised to be called back to the office then, and I was suspended anyway. So I took my suspension paper and I went home, and the next day John was suspended. The same day I was suspended, Chris Eckhart was over at Roosevelt High School. He was suspended. But it's funny
How long were your suspensions? How many days were yours?
The suspension was for as long as we would not, follow the rule, as long as we wore the armband. So it was like a week. It was a few days before Christmas vacation. So we were out for those few days. And then when school started back up in January, we went back to school without the armband. But it's really funny that I took off the black armband, but I was suspended anyway. But I did learn an important lesson from that, which is that you can be scared, you can be nervous, and you probably will be when you speak up about something. But you can still make a difference And so that was the lesson that I learned from that.
Good. So I'm just going to go through this slide quickly, but I am going to ask you just as a heads up about the ACLU's involvement in just a second. So this is a chart that shows how Mary Beth Tinker's case went through the court. So it started out in U.S. District Court, and you can see that at that level, the school officials won, and they said that it was reasonable because the school needs to keep order to be able to function as a school. And so then it was appealed, and by Mary Beth, it's always the person who loses who appeals. So then it went to the U.S. Court of Appeals for the 8th Circuit. Once again, the Tinkers lost at that level. So then they appealed to the Supreme Court. And depending on where you are in your studies, you may or may not know this, but it is very difficult to get the Supreme Court to hear your case. It takes about 1% of the cases that are brought to it. So it's 99% of the time you're not going to get your case heard at the Supreme Court. But this case was chosen because it presented First Amendment issues, and that's really something that's really important to the court, particularly when it deals with political speech, which this was. So obviously you're from sort of an average family in Iowa. So how were you able to get your case propelled into the United States Supreme Court?
Well, yeah, what happened was we lost, as you said, at the district level, and then we lost at the appeals level. Well, over in Mississippi, some students had worn buttons to school to protest the murders of Cheney, Schwerner, and Goodman, the 3 young people who were murdered by the Ku Klux Klan. And they had a case also going through the courts, and at the appeals level, they won. The name of their case is Burnside. So right before we lost at the 8th Circuit, they won at the 5th Circuit in Mississippi. And that can happen, of course, in different courts, different parts of the country. So now you've got one appeals court saying students do have a right to express themselves in school, and another one saying no, they don't. So that's called a circuit split, when 2 courts disagree. And that kind of helps get your case heard at the Supreme Court. But the American Civil Liberties Union lawyers had taken our case, and our main lawyer, Dan Johnston, he was wonderful, a young lawyer right out of law school. And he was so kind and good, and a really good lawyer. But he, because of the American Civil Liberties Union, the ACLU, goes to the Supreme Court more than any organization in the United States, because their whole thing is to, speak up for civil liberties and the First Amendment.
Great. So this question that you're seeing in front of you, are Armbands speech, became the really important question in your case, right? So, and because you didn't say out loud, you weren't walking down the halls saying we should have this truce and the war in Vietnam isn't something we should support, you quietly wore these armbands. So what did your side of the case, your lawyer who you were just speaking about, how did you make the argument that armbands are speech?
Yes, that was a big issue. You're right. It was central about symbolic speech. And by the way, we didn't have those peace signs on the armbands when we wore them. They were just plain black. But the lawyers, argued that we were expressing ourselves, and that youth should have a right to express themselves. And what better place to do it than school, when students are learning about democracy and learning about the Constitution, and where they can have good discussions with their teachers and the administrators. And there was also an issue, I'd say, about what are the rights of young people? Because young people are kind of a discriminated group. People didn't think that they had particular rights, and that's been a big issue through our history. What should be the rights of children and young people? So that was also a big issue, because the lawyers for the school district basically said that, hey, these kids should, not speak up unless it's an issue that the administrators want them to talk about. And our lawyer said, no, wait a minute now, these kids should have a right to express themselves also. They weren't hurting anybody, they didn't disrupt school. And when the kids in Mississippi won their case, the Burnside case, the court said they should win. Why? Because they had not substantially disrupted school. So that is where that standard comes from. It comes from Black students in Mississippi speaking up against the murders of Cheney, Schwer, and Goodman for registering African-American voters. So all of these issues are very much with us today, voting rights, but the issue of substantial disruption goes back to that case that started in 1964 in Mississippi.
Mary Beth, we did just get a question from a student asking what the deciding factor was in taking the school district to court rather than just dealing with the suspension.
Yes, I think it was that sense of this not being fair. And that's a very strong thing for young people. Young people have you have a sense when things are fair and not fair. And a lot of adults will tell young people, well, you know, life's not fair, so just get used to it. But I say, don't get used to it, because that's one of your superpowers, seeing that things are not fair and then wanting to change things that are not fair. So we had that feeling very strongly that, wait a minute, we didn't do anything to hurt anybody. We were just saying we were sad about war and killing at Christmas time. And that's not right, that they should tell us that we should be suspended for doing that.
Okay, so I'm sure it's of no surprise to anyone that Mary Beth won her case, because if she didn't, we wouldn't be having this conversation oh so long later. But here is a headline from the New York Times on the day that the day after your case was decided. The High Court upholds a student protest, and the second headline, it actually even calls it a peaceful protest. So I'm sure the students would like to hear how you felt when you realized that you won, and where were you and how did you find out and all that kind of stuff.
It was crazy because by this time we had moved to a whole new city, to St. Louis, which to me was this big city, and I was from Des Moines, Iowa. So now I was at this new school where I didn't know anybody. And so I was really, really shy and everything. And I mean, the last thing I really wanted was to have a lot of attention to me. So there was that issue. And the main thing was, though, that it was really hard to be real happy about it because it was one of the worst years for the war in Vietnam. 1968 and 1969 were terrible years in Vietnam. There were many, many deaths, and there were also many injured, wounded, and we were hearing about it every day on the news. So, you know, then, oh, wow, yippee-yi-oh, now we can wear a little black piece of cloth on our arm. I didn't think it was such a great victory, and I didn't think it was such a great thing at the time. But, you know, I've come to be, of course, happy about the ruling because of the rights of young people and how we didn't exactly stop the war. That didn't happen until 1975. But we did, you know, win this precedent for young people to be able to speak up about war and so many other issues that affect your lives.
So I probably should have said before I showed that slide for those students who haven't studied the Supreme Court is that it takes months and months for the Supreme Court to make a decision. So it's not something that you find out right away, like in a trial where you find out, you know, the same day or the next day. It takes months and months, and then you don't know when they're going to make a decision. They just announce that they have a decision. So it can be kind of a surprise even to the people involved in the case when their case is decided. And Mary Beth just talked about the precedent that her case set for student speech. So we're going to talk more about what precedents are in just a moment, but this is the decision and the really important words from the decision that I get quoted a lot. And that is that it can hardly be argued that either students or teachers shed their constitutional rights to freedom of speech or expression at the schoolhouse gate. So the idea that students and teachers have First Amendment rights within their schools. Now today to us probably doesn't sound like that all that newsworthy, but at the time it certainly was, because students being seen and not heard was the norm in a lot of schools. So that was a picture of you taken shortly thereafter. Did you do anything to celebrate the win in the moment? Did you, get ice cream or?
Well, yeah, my mom went and got some ice cream and soda pop. My dad was out of town and John was already in college. So it was just us and my sister Hope that were there. But I want to add also, Kathy, that when the court made the ruling in favor of student speech, they said there are two things students cannot do with free speech. And number one is to substantially disrupt school. And for that, they quoted the Mississippi case. And number two, impinge on the rights of others. You're not supposed to impinge on the rights of others with your free speech. So whatever that means, and that's been debated ever since. And that's a lot of the reason why certain hate speech can be blocked in school now, because of that second part of the Tinker ruling.
That's great.
So,
Mary.
oh, no, go ahead. You have a question?
We did, and one that was exactly what you were just talking about, Mary Beth, so I thought it would be a good time. We have a student who wants to know what exactly determines if something is substantially disruptive or not, and I think you're about to get there, so I just wanted the student to know we're on it.
No, that's a very gray area. It's supposed to be, according to the ruling, substantial disruption. There was a girl at Buckeye Union in Arizona who wore a Black Lives Matter shirt to school a few years ago, and a student was arguing with her about it. So the principal said, well, that's a substantial disruption. You can't wear that shirt. Well, that's not a substantial disruption. And she was, in the end, allowed to wear the shirt because the school board lawyers talked to the principal and he realized that that was a mistake. And so, yeah, what is a substantial disruption? That's a question.
Yeah, and we're going to answer it a little bit with some cases. So Mary Beth mentioned the substantial disruption test standard, and sometimes they call it now the Tinker test, so it's named after her, and that the schools try to figure out what is a substantial disruption. And we talked just a minute ago about precedents. So precedents are court cases that have been decided that are similar to some issues that come up. So what the courts try to do, all courts try to do, is to look at the cases that have already been decided and decide if they are similar to the cases that they're hearing or not. And so they apply what's called stare decisis. It literally means to stand by the things decided or to let the decision stand. And it's the idea that courts should look to precedent to decide how to decide things. And certainly Tinker is the precedent for speech, but there have been some other cases. And for each of these cases we're about to talk about, one of the things that the Supreme Court does is to look at the case, the case that's being heard currently, and see if they are analogous to the cases that have already been decided. So that means that they're very similar, or are they distinguished, that they're very different. So there are a couple really important cases that Tinker v. Des Moines was used as a precedent for. And one of those cases is Bethel School District v. Frazier, so significantly after Tinker. But this case dealt with a student who gave a speech in the school auditorium. It was for someone else who was running for office, and there was a lot of innuendo. So he didn't say like the words that you can't say, but he made a lot of inferences or, references to things that were lewd or indecent. And so it caused a disruption in the auditorium at the time. People were talking about it. And so in this case, the Supreme Court decided that schools can prohibit the use of lewd, indecent, or plainly offensive language, even if the words themselves are maybe not on the list of words you can't say. But if you make them, put them together in a way that is lewd or obscene, that it can be restricted. And one of the important parts of the precedent of this case is that it said that if the speech interferes with the school's basic educational mission, that it can also be restricted. So in other words, if someone had walked into that auditorium and heard his speech and maybe inferred that the school thought what he was saying was okay, and it thought it was okay to say that in a public way, that can be also restricted. So that's a really important case that might carry over to the next case we're going to look at. And another case, which maybe a lot of you have heard of, is the Bong Hits for Jesus case. So this is, the name of the case is actually Morse v. Frederick, and it happened in 2007. And this was a case about a young man, Joseph Frederick, who did not go to school one day. And it was a day that his classmates were going to go on a field trip to a nearby road. They lived in Alaska, and when they got to the road, they were going to watch the Olympic torch go by. So it was the year of the Winter Olympics, and they were going to run by with the torch. And so the school said, let's let the kids walk down to the main road, watch the torch go by. So this student decided that he wanted to get on TV. And so he stayed home that morning and possibly then made this poster. You can see it's sort of that poster, paper that the Student Government Association always makes banners on, and duct tape. So I don't know if you can tell from that picture, but it's actually duct tape stuck to the poster paper. And he wrote a saying that he saw on the bottom of a skateboard or a snowboard that said "Bong Hits for Jesus." He said it didn't have any specific meaning to him, except that he thought it would get him on TV. So at the appointed time of the running of the torch, he joined his classmates at the road, and he was with the rest of the students from his class. And as the torch ran by, they unfurled this banner, and he did get on TV. He also got in trouble. So the principal came over, took the poster, suspended him. And then he and his father tried to sue the principal to say that his suspension was unwarranted. And so there were a couple questions in this case. One was he at school, since he didn't go to school that morning? Did the school have the ability to discipline him because, was he even at school? And the Supreme Court decided pretty easily that he was at school, that even though he didn't go to school that day and walk there with the students, that he joined his classmates, and as he joined his classmates, that made him under the supervision of the school. The next part was the harder question, and the next part was, did his speech, "Bong Hits for Jesus," was that any kind of violation of school rules? Was that something the school could restrict or not restrict? And so the Supreme Court decided ultimately that because of the bong hits part, that there was a drug message, a message that promoted drug use. And so it could be restricted, even though he said, and it was, pretty well established, that he wasn't actually promoting drugs. They said that a reasonable person could see that and think that he was advocating drug use. And so that part of the policy could be restricted, and that wasn't a violation of his First Amendment rights. So if you're keeping score, Mary Beth won her case. Thus far, the students are not winning their cases, and the schools have been able to prove that the students have either caused a substantial disruption or are doing something counter to the educational process or the educational mission of the school. Mary Beth, anything quickly? We're running a little behind schedule, but anything quickly you'd like to add about those two cases before we move on to
well, in the Bong Hits for Jesus case, it was Clarence Thomas, the justice, in his decision, who said that actually the Tinker decision should be overturned and that students don't have rights according to the Constitution. But also in between was another case called Hazelwood versus Kuhlmeyer that had to do with student press freedom. And that's a very amazing case also, where students are organizing even today to have states pass laws to protect student journalists. So that's called Hazelwood. And a group called the Student Press Law Center is very involved with student press rights. So that's another important issue, press rights for students.
Okay, so we're going to get to the part where we talk about the case that was just heard recently. It was heard last year, Mahanoy Area School District v. BL. And then we try to apply what we know about Mary Beth's case and then the last two cases that we talked about to this case. So this is a young woman named Brandy Levy, and we know her name, but now, because she's been public about it, she's been interviewed and she's been in the press. But the Supreme Court, when it deals with cases that have to do with minors, often uses their initials. So the name of the case is formally Mahanoy Area School District v. BL. So we'll refer to her as that. But we do know her name is Brandy Levy, and she was a cheerleader. She made the cheerleader as a freshman, cheerleading team, the JV team as a freshman. And she was hoping as a sophomore to get on the varsity squad. And she tried out and she didn't. This is happening in this, in the spring of the year before. She would be on the new team, and she didn't make it on the varsity team. So she was really disappointed. And she had some other things going on too, with the travel softball team she was on in her finals for her classes. So she and a friend were at a convenience store on a weekend. It was a Saturday, and that's an important part of this, is that they're off campus on a weekend. And they use Snapchat to take a snap. And in that snap, she and her friend are holding up their middle fingers, and she wrote F school, F softball, F cheer, F everything. Although she did not use the asterisks, she wrote out the word in her snap. And that might be important, so that's why I mention it. It's very important to know that she went to a public school, because the rules are not the same in a private school. They really have a lot of freedom to do what they want about student expression. And so most of you know what Snapchat is, but so I can't assume that everyone does. Snapchat is an app that allows you to post snaps, but then they disappear in 24 hours, and they're not kept and people can't go back and look at them. But everybody who uses it, I would assume, knows, and Snapchat cautions their users that people can take screenshots. And of course, if they take a screenshot, then they have that image that they can then pass on. So on the app itself, it disappears, but if someone screenshots it, it can be permanent. So someone screenshotted BL Snap. And one of the people who's had the screenshot shared it with her mother, who also happened to be a cheerleading coach. And she was concerned, talked to the other coaches, and they decided that this broke some rules that they had decided for their school about conduct. And some of the rules for conduct was that cheerleaders wouldn't use obscene gestures, that they wouldn't use profanity, foul language and inappropriate gestures. I'm reading right from the thing right now, that they would have respect for the school coaches, teachers, and other cheerleaders. And that there would be no toleration of any negative information regarding cheerleaders, or coaches placed on the internet. So they had agreed to these rules. And so BL was suspended from the cheerleading team for a year. So she wasn't suspended from school at all, but she was not allowed to be on the cheerleading team for a year. So that might be important later, the fact that she wasn't suspended from school, but was suspended from the team. If there are questions about the specifics of this case, you can text them and we'll try to answer them. There are lots more details for sure. So we're going to try applying Tinker to Mahanoy. So in this case, very much like Mary Beth's case, the student, with the help of the ACLU, brings her case up through the courts. And so she sued, asking for an injunction. So she wanted to be back on the team. She wanted the court to make the school put her back on the team. She wanted to have her disciplinary record be expunged. She wanted them to declare that her rights had been violated, and she wanted some money damages. So she wins at the first level, much like, or sorry, not like Mary Beth. She wins at the first level, and the court says that she wins because her snap was not disruptive enough. So, you know, there was a little chatter about it at school, but there were no fights about it. There was no educational time lost. One of the cheerleading coaches said that she lost some instructional time because, who taught math, said she lost some instructional time because some of her students were asking her about it during class. But other than that, they couldn't find a disruption. So that's what happened at the district level. And then at the Third Circuit level, the student wins again. And this time she wins not because they didn't even look at how disruptive it was. She wins because the Third Circuit says Tinker doesn't apply because she is off campus. And the school just emphatically cannot restrict your off-campus speech. So that gets it to the Supreme Court. So when we think about applying Tinker, I want to start by asking Mary Beth about how she would apply her case. And we know a little bit about the answer to that because Mary Beth and her brother, through their lawyer, Bob Corn-Revere, filed what's called an amicus brief. So when Supreme Court cases go to the Supreme Court, the two sides write their arguments for why they should win. So in this case, Mahanoy Area School District wrote a brief saying this is why we should win, and BL wrote a brief saying this is why we should win. But other organizations and individuals can also file what are called amicus curiae briefs or amicus briefs. And they are when interested parties want to express to the Supreme Court how they see the issue and what their argument is and who they support in the case, who they think should win in the case. So Mary Beth and her brother, through their lawyer, filed an amicus brief in this case. And I'm wondering, Mary Beth, if you can talk a little bit about your brief and how you think Tinker applies to the Snapchat case.
Yes, well, it was an important case because of the reach of the school censorship that this case involved. And if the school district had won the right to monitor students out of school speech and then to punish it at any time or any level, that would be way too much power on the part of administrators. And so many administrators that I meet all over the country, they don't want to have that kind of, responsibility and power to monitor your social media 24 hours a day. So that was one of the main problems. And also the censorship, the put down of student expression, because as it turns out, and being a nurse working with kids so much, I've learned that expression is a very big part of health for young people and for teenagers. And you have to be able to express yourselves. It's good for your physical health, your social health, your mental health, all of it, to be able to express yourself. And Brandy was saying, her expression about how she felt about being rejected by the cheerleading team. And yes, she used a curse word that is common in our culture, but I felt that she had a right to express herself. And not only did she have a right, but it was important for students to be able to express themselves about all the things that are going on that affect your lives.
Okay, we are going to stop here for a couple questions that have to do with the facts of Mahanoy before we talk about how this case ended. or applying Tinker to Mahanoy. So there are also really other good questions that are about, sort of overall things, but we're going to stop to take some of those questions now. So I'm saying in the Q&A, why would she be gone from cheer but not suspended from school? So I'll just take that one because I read all the briefs and listened to all the oral arguments. So in their school, she didn't really violate any rules because she was off campus. So she didn't violate any school rules. But on top of the school rules, there was sort of this other level of agreement that she agreed to submit herself to in order to be on the team. So maybe some of you are in schools where teams ask you to sign pledges or just, have something where they say, by being on the team, you agree to this. And so this was put out by the coaches, not the school leadership, like not the principals. And that was where they agreed that they wouldn't use, obscene gestures. They wouldn't use profanity. They wouldn't talk bad about cheerleading or the other cheerleaders or the coaches. And so they felt that she could be, because she broke those rules that she agreed to, even though she broke them when she was off campus, that they could suspend her from the team. But there was no rules that she broke that were school rules that would allow her to be suspended from school itself. Bianca, did you have questions that were about?
No, not about this part. Okay. So if you've sent me a question, I think we're going to try and get to it at the end.
Yep.
And I'll just add, Kathy, that one of the reasons why she won at the appeals level was because the court said that you cannot ask students to sign agreements for athletics or extracurricular activities that violate the First Amendment, and that was what she had been asked to do by signing that pledge.
Thank you. Thanks, Mary Beth. Okay, so there were a lot of arguments from the school. So when a side makes their case at the Supreme Court, they have lots of different arguments. They take a lot of different tacks, and you can see a lot of these. One of them is specifically about Tinker v. Des Moines, and that the school district said that they agree with Tinker v. Des Moines, but that doesn't mean that schools have to ignore speech that happens out of school if it disrupts the learning environment in school. And it used a lot of examples the school did. You can see in the other arguments about, well, what about bullying? Can we, if you say that we can't restrict this speech, does that mean that people could be bullying people, via Twitter, whatever, Snapchat, or, could people be bullying other students? Could they be harassing faculty? It talked about cheating, if we're not allowed to restrict this off-campus speech, could students share answers to tests, share answers to homework assignments? So they had lots of different examples about if you can't restrict off-campus speech, what are the other, what are the other things that could happen other than just this tweet, this snap. So that was the arguments for Mahanoy, and they definitely used Tinker. Both sides used Tinker. Is one of the things I want you to realize is that both sides said that the Tinker v. Des Moines case meant their side should win. So the school decided to focus on the part that if there's a substantial disruption, the student speech can be regulated, even though they're saying if it happens off campus. And for BL, the big argument was, well, maybe Tinker doesn't even apply off campus, but even if it does, you have to prove there was a substantial disruption. And in this case, you can't prove that. There wasn't a fight, there wasn't a school assembly to discuss it. There wasn't, there was one math teacher said that a couple of people asked some questions. And so they said, even if Tinker does apply, which we're not saying that it does, but even if it does, there was no substantial disruption in this case. So the Supreme Court decided in favor of the student 8-1 in this court. That's pretty amazing. Justice Thomas was the only one to disagree, and you're probably not surprised by that because Mary Beth said that in one of the earlier cases, he came right out and said that Tinker should be overturned. And in this case, they decided that it was kind of a double-edged sword for student speech, which a lot of these decisions are. They said that they're not saying that schools can never regulate off-campus speech because, you know, if it does rise to something really disruptive or really dangerous for student safety, that maybe they could. But in this case, they clearly couldn't because there wasn't a substantial enough reason for restricting her speech. So there wasn't a disruption, there wasn't a connection to the school that was solid enough to be able to restrict that speech. There's a picture there of who voted for what, but like I said, Thomas is the one who dissented. That's what it's called when a justice doesn't agree, and they write their own arguments for why they don't agree. And largely Thomas didn't agree because he believes that the school should have a lot of leeway in what they're able to restrict as far as student speech. Mary Beth, anything that you want to add quickly before we go to Q&A? Because we have some great questions.
No, let's just go ahead. I mean, the ruling left the door open for future, involvement of the school with out of school speech. So it's still sort of an undecided area, but when it comes to bullying, there is still, plenty that schools can and sometimes are required to do, even if the bullying is outside of school.
Awesome, thank you. So I'm gonna start with some of the ones that are in the Q&A. We have a question that says, clearly this has helped shape your life. What do you think is missing in our current curriculum, classrooms, and the kitchen table when it comes to American civics?
Well, I think that students should have more say about what is included and what they want to hear about and what they want to talk about, even if it's controversial. This is really a case also about how to deal with controversy in classrooms. And students, want to talk about things, and we can't just eliminate controversial things. So I think that would be something missing, more student involvement in determining curriculum and how schools are run, really.
Great, thank you. And how did your parents feel knowing that their daughter would have the family name in the history books forever?
Well, my dad, I told you, came around to accept and support us for what we had done. And I think they were glad that we had internalized their values of speaking up and putting your values into action. We had been raised in the faith community, and they believed that you should put those values into action.
Awesome.
Your camera is off. I'm not sure why that is, but if you can, maybe you could turn your camera back on.
Okay.
That's okay. There you go.
There it is.
Great.
Great. So speaking of how folks reacted, someone wants to know how the other students at your school reacted to your suspension.
Most students ignored the whole thing, I'd say. I mean, some of my friends talked to me about it and things, but it wasn't that big a deal, really. And at the other schools, at the high school, some students got hassled, but a lot of students, just really kind of ignored it. I don't know, later on, even the teachers, I was kind of surprised when we won that the social studies teacher didn't really say anything about it. Like, hey, everybody, guess what happened to Mary Beth yesterday? But mostly it was just kind of ignored. I think a lot of people really didn't know how to talk about it because it was controversial, but we need to learn and practice talking about controversial things with respect for other people and other people's viewpoints. And that's what this case is about also, I think.
Great. I know we've talked a little bit about how it's rare and lengthy to get a case to the Supreme Court. And we have a student who wants to know how long both cases of Tinker and the Snapchat case took to get through the Supreme Court.
Yeah, for Tinker, it was about a little over 3 years. I was in 8th grade, and then I was a junior in high school when we won. For Mahanoy, It was about the same amount of time. I think Brandy is a freshman in college now, and she was in 9th grade when it started.
And the decision from the time it was argued on April 28th, and it was decided on, this is Mahanoy, on June 23rd. So it took 2 months from the time it was argued till they put out a decision.
Awesome. So we have someone who's asked, I know you said the court decided both students and teachers can't have their First Amendment rights suppressed, but don't teachers sign away a lot of those rights with contracts?
Yes, and the rights of teachers and the rights of students are connected. And we could have a whole webinar on the rights of teachers. It's really fascinating. It really, in many ways, teachers have less rights to free speech than students. And some of that has to do with contracts, and that teachers are there for the benefit of students. And so there have been cases that furthered teachers' rights, and there have been cases that cut back on the rights of teachers. Just like there have been cases for students' rights that have been cut back, there have also been cases that have cut back on teachers. And there's so many controversies going on right now. Teachers speaking up about wanting to speak to students about anti-racism education. Teachers wanting to be able to, have a banner behind them when they're doing a video chat. There was a big issue about a year ago with a teacher that had a Black Lives Matter banner behind.
I just wanted to say that a lot of these cases are being appealed to the Supreme Court. They have declined to take them. So I mentioned earlier that the Supreme Court doesn't hear 99% of the cases that are brought to them. But there is a real possibility that at some point they can't push that off anymore. They'll have to raise questions about teacher expression. There was one last year about a teacher who kneeled at the 50-yard line after every football game. And the school wanted to fire him if he didn't stop doing that. I was really hoping the Supreme Court was going to take that case. They never did. But at some point, the Supreme Court probably will have to take some of these teacher expression cases, and then we'll have a more insight into where those lines are. But it'll probably take the court taking one of those cases before we really know too much.
I do think teachers need to be role models for students and help students talk about controversial things and not shy away from controversial things, but model how to talk about things, and to show respect for people when there's disagreement.
Great. Someone asks what your thoughts are on parents disciplining speech off campus versus schools disciplining their speech.
Well, yes, there is a big issue of children's rights that extends to parents as well. And there are limits. There are limits to all rights. The First Amendment, there are limits. The Second Amendment, there are limits. All rights have limits. And there are limits to parental rights as well. You can't abuse children. You can't, deprive them of their needs and things like that. So being a nurse dealing with children, I know that this is a huge issue as well, but there's much more leeway for parents to be able to discipline kids than there is for schools, and for the public school, which is considered an extension of the government.
Someone would like to know what your next move was after you won your case. Then what?
Oh gosh, after I won my case, I was probably studying for some test or some paper that I had to write, and I thought school was kind of stressful. I was a junior in high school then, and making friends, and so shy. When I first got to that school, I didn't even go to the cafeteria for lunch because I was so shy. I usually ate my lunch on the steps or something. So I was probably just trying to figure out, what I was going to do that weekend and how I was going to get through with friends and things. But yeah, the war was a huge issue. It was still going on. And there was plenty going on the racial justice front as well. You know, 68 was when Martin Luther King was killed, and then Robert Kennedy. I mean, so there was plenty going on, just like now.
Just like now. We have another question about freedom of speech being a problem in boarding schools. I think the question is a little bit about how that might be different than public schools.
Yeah, it's very important. I mean, a lot of rights, you have to use your rights if you don't want to lose your rights. It's kind of like your muscles. So you have to use them. If you're at boarding school or wherever you are, even in private schools, I think, you know, that students have to speak up for what they, you know, want to express and for their needs to be met. And one of those is expression. So wherever you are, if you're in a private school, a boarding school, whatever, you can find ways to express yourself. Most of these issues aren't decided in court. They're decided in other ways, through negotiations, through, you know, other actions that students take with administrators, just to show that they're really serious about having some say about their lives.
Great, thank you. That's the list of questions for now. I'm going to wait and see if a couple more roll in, but that was the chunk of them for now.
Great.
Great.
So this is a picture from when Mary Beth used to speak to my students. And if there's ever any extra time, I love for her to talk a little bit about the public reaction to her case. So I know we've asked questions here about how did the other students react, but what was the wider reaction to your case?
Yeah, some people got really, really mad at us. I think for one thing, a lot of people think that kids shouldn't speak up about anything. First of all, you know, kids should be seen and not heard, things like that. There's kind of a discrimination, as I said, against young people. So there was that. And then there's also the idea that some people think they get to decide what is patriotic and what the Constitution means. And so, you know, if you speak up against war, then, oh, you must be patriotic. So that's one of the postcards we got. And I have my postcard right here, but and that red thing was saying that we're communists. We must be communists if we speak up for peace in Vietnam. My mom would always say, we're not communists, we're Methodists. But yeah, people threatened to bomb our house on Christmas Eve. A lady called me on the phone and said, is this Mary Beth Tinker? Yeah, and she said, I'm gonna kill you. You know, just because we were speaking up for peace at Christmas time. That's really sad, because we have a constitution and we have a society where everyone's voices should be respected. And I really think that's what the First Amendment is about. Respect for different opinions and the beautiful tapestry that is our country of all different people weighing in on the issues that need to be decided and to help decide the direction of our country and our world. And thankfully, young people are a big part of that, because it only comes natural to young people, all of you students, to want to have a say and to want to express yourselves and to be creative and to care about what's going on.
I have one last question, then I'm going to turn it over to Tammy, who has resolved her technical difficulties. But so for the longest time, your actual Armband that you wore that day was in the museum in Washington, D.C., and in a big exhibit about the First Amendment. And people were able to go and see it and take pictures with it. And there's a picture of you with that exhibit. But unfortunately, the museum has closed to the public. So where is your Armband today?
Well, that's kind of a funny story, because that little yellow notebook you see up there, that's a school report I did when I got back to school that year in 8th grade. And we had to write a report about what did you do over Christmas vacation. So I told about wearing the armband and I pasted it in there. But that report and the armband that's inside of it is going to a First Amendment museum that's going to be in St. Louis at the Court of Appeals there in St. Louis, which is where we lost our case back in the day. But now they're featuring the case in their First Amendment museum. So I'm going to loan them that. They asked to have it at their museum. That's where it's going. That was the first time I flew in an airplane, was to go to St. Louis for that appeals court hearing when I was in about 10th grade, I think.
That's a great way to wrap up. So I'm gonna say thank you to Mary Beth for being a wonderful host and for sharing your story with us. It's so inspirational, and I'm gonna turn it over to Tammy for some fun.
Thank you, Kathy and Tammy. And I just want to add, if any of you teachers or students want to write to me at tinkertour@gmail.com, and I'll write you back.
I just want to say thank you so much to Mary Beth for coming out and having a conversation with our students and teachers. It is so inspiring because it shows us, one of the things I love most about our government and the country is the idea that ordinary people, including a middle school student, has just as much right to take a case to the Supreme Court and just as much value to have their opinion heard and protected. So every time I hear Mary Beth, it is so inspirational to me. I grew up in high school reading about the Tinker case, and it's, thank you so much for coming and sharing with us. And I want to thank Kathy and Bianca and Street Law because they were able to help organize this for us here in Arizona. I think it's really important that we honor and celebrate the legacy that Justice Sandra Day O'Connor has created and is still creating for civics education in this state. And I think there's no better way than partnerships like we have with Street Law, being able to bring in really great things for our students and teachers. We have recorded the session and we'll make it available to teachers who want to share it with their other classes, or if you have other peers that you'd like to share it with. And then Civic Celebration Week is still going on, and we have lots of fun resources. We have a Civic Story Hour where we have brought in civic leaders in Phoenix and Tucson and Arizona, and they are reading civic themed storybooks and telling their own biographies of what's connected them to government or to civics and things like that. So please reach out, teachers, if you would like some more information. It's on the website. And we're going to go ahead then and end this wonderful, wonderful midweek celebration of civics, Justice O'Connor, and all the students and teachers, and the ability to have your rights protected, to learn about the Constitution, and to see that even if you can't vote yet because you're a kid, you still have a lot of power to make change and to be a part of this democratic republic. Thank you.
Thanks, Tammy.
Thanks, everyone. It was so great being with all of you, celebrating young people and democracy and the First Amendment and Sandra Day O'Connor's work in civics. And so all of you take care and have a good month and a good year.